What's up? What's good? It's your boy and your favorite YouTuber, Tommy Springfield, aka the king of all things related to talk. And as you can see by the title, today we gonna read the paperwork of the lawyers on the YSL, the Young Thug trial, trying to get the judge kicked off the case. And there's a lot of kooky, crazy things that's been going on in this case. And if you've been following it, you will definitely know what I'm talking about. The judge has been holding secret meetings with the prosecution, and he got caught, and he's pissed off now. And his whole thing is, who told you? He don't care about Young Thug's freedom or future. He don't care about nothing. All he care about is outing the rap. So, as you can see on the screen, we got the official paperwork, and this is the motion to recuse Chief Judge, whatever, Euro Glanville. So this is a motion to try to get the judge off the case. And like I always say, click that like, share, subscribe, hit the bell, click all so you can get notifications every time I drop one of these videos and give my unbiased opinions. And why not? It's never gonna hurt you. It's only gonna hurt the channel grow. You ever wonder how your favorite big channel got to 1 million views? That's because people hit that like, people hit that share, and people hit that subscribe and gave their channel a chance to blow up. So as we get straight into reading the paperwork. So the defendant, Mr. DeMonte Kendrick, by and through his undersigned counsel, without waiving any other rights to which he is entitled, files this motion to recuse Chief Judge Glanville from continuing to preside over the present case and request for the present trial to be temporarily halted until the present motion is heard by another judge of the Superior Court, consistent with the uniform rules of Superior Courts of the state of Georgia, stating the following. So, these judges are accusing him of doing things, and they're asking him to get off the case. Like, we don't want you on the case, bro. We want you off this case. We don't want you on it. So, that's what's going on here. Hold on, I'm trying to get some things straight over here. Don't mind me. It's funny when you do stuff, you can't do it again. So there's a lot of things that's been going on. The judge locked up Young Thug's lawyer, which the higher courts already overruled and ruled that he doesn't have to go to prison and all of that. So this trial is becoming a mess, and it will soon be a mistrial. But y'all know how we do, man. This is a 420 channel, friendly channel. So get your blunts, light them up, get your coffee, and get your tea, because it's time to get ready. It's time to get ready. So it is vital to the functionings of the courts that the public believe in the absolutely integrity and partiality of its judges, and judicial recusal serves as a linchpin for the underlying proposition that the court should be fair and impartial. Munday versus Magnolia Advanced Material, that's just the law. The present case involves a 65-count RICO indictment against 28 individuals. Jury selection in this case began in January 2023, with a jury trial beginning in November 2023. Given that the state has presented less than half of its current witness list, which the state has announced could be increased based on circumstances, the trial should last well into 2025. The 6 defendants presently on trial, including Mr. Kendrick, have been denied bond and incarcerated for over 2 years. Yeah, well, that's definitely that good. I spoke nothing but the best. And I only go places where I'm welcome. And what I mean by that, when I go get my marijuana, I don't just have a medical marijuana card. You know, a brother like me got a gold card. You know what I mean? I got them gold cards. That's metal. That's metal. When I go get I don't have a marijuana card. I got a gold card, and it's metal. That's a chunk of gold right there. I slap that on the table in the dispensary. Bang! And they take care of me. Because I'm kind of special, you feel me? But, you know, let's get back to these cases. A central figure, perhaps, in the state's case is Kenneth Copeland. A central figure in the state's case is Kenneth Copeland. On Friday, June 7th, 2024, Kenneth Copeland was sworn in despite being warned by Chief Judge Glanville that incarceration may be the result of refusing to testify. After being given a grant of immunity, Copeland refused to testify on that day. See XYZ affidavit. Copeland was ordered incarcerated by Chief Judge Glanville on that date, and Chief Judge Glanville instructed Copeland and all parties that Copeland will be returned to court on Monday, June 10th, 2024 at 8:30 a.m., where Copeland would announce whether he was prepared to testify or not. So if you're following me so far, what happened on June 7th, Kenneth Copeland was on the stand, and he used to run with Young Thug and the YSL crew, but he started telling, and he started doing a whole bunch of stuff, so everybody wanted to kill him. YSL wanted to kill him, the ops wanted to kill him, and they thought he murdered Nut, which is who Young Thug is being charged with in his RICO. So everybody was trying to kill him, and he was telling. So they brung him to this trial as their star witness to get him to tell on Young Thug, but it ain't working out. But on this particular day, he decided that he wasn't going to tell on the stand, and the judge locked him up for the weekend. On Monday, June 10th, after the weekend, all defense counsels were present in the Fulton County Courthouse at or around 8:30 a.m. Admitted interest into courtroom 1 seat and seated within by 9 a.m. Defense counsel waited and waited. Between 11 a.m. and 11:30 a.m., Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. Attorney Brian Steele, counsel for defendant Mr. Williams, which is Young Thug, if you don't know that, inquired with the court as to the delay and what occurred prior to Chief Judge Glanville taking the bench. His inquiry was not accepted. So they come into court on Monday after Copeland was arrested for the weekend, and they sitting there at 9 o'clock like they're supposed to, waiting, and nothing happens. 10 o'clock comes by, nothing happens. 11:30, the judge come out and say, okay, he's ready to testify, and Young Thug's lawyer, Brian Steele, asks what happened. The judge didn't pay him no mind. Excuse me. Yes, this is a 420 channel. Like yours, hit mine, do whatever you gotta do. But Get your tea, get your coffee, get whatever you do, and let's read this paperwork together. Remember, hit that like, share, subscribe, hit the bell, click all so you can get notifications. Why not? It only helps the channel grow. Never gonna hurt you. Unknown to any member of the defense counsel, during the waiting period in the morning, upon information and belief, an ex parte meeting was held in Chief Judge Glanville's chambers on June 10, 2024. Among Chief Glanville, ADA Love, ADA Hilton, and other members of the Fulton County District Attorney's Office, deputies, sworn witness Kenneth Copeland, and Copeland's attorney. No member of the defense counsel was present at the ex parte meeting, despite the subject matter of the meeting being a critical phase of the trial. So, as you can see, they met while the defense is all outside, sitting there waiting to start their day's work. The judge, the DA, and the witness, Kenneth Copeland, aka Little Woody, is all having a secret meeting without the defense. And if you know just a tad bit of the law, if you know a smidget of the law, if you know a drop of the law, you know something ain't right about that. Why wasn't the defense there? But let's continue to read. Upon information and belief, neither Chief Judge Glanville nor any member of the court staff nor the Fulton County DA office made any member of the defense counsel aware of the ex parte meeting, either before the ex parte meeting was held, during the ex parte meeting, or after the ex parte meeting. Copeland briefly testified prior to a lunch recess. One or more members of the defense counsel were later made aware of the ex parte meeting and sworn witness Copeland, and made aware of at least some of the content and subject matter of the ex parte meeting. Upon information and belief, the following events occurred at the ex parte meeting with sworn witness Copeland in chambers of Chief Glanville. So, this is a peek into what happened at these secret meetings. You know what I'm saying? Which is illegal. You can't have a secret meeting with the witness and not include the defense. So what this judge is doing is illegal. What the prosecution is doing is illegal. And this case will be overturned. But the problem is about that is you've been done give them 6, 7, 8, 10 years by the time your appeal come. You know what I'm saying? So they get you. They get you. You know, pills should be automatic, and immediately, but that's how they get you. You do time waiting for that appeal. So even when the case get overturned, you done did the time. They ain't giving you no money. They ain't paying you for your time, and you done did the time. But upon information and belief, Copeland announced that he would invoke his Fifth Amendment rights and not testify. Upon information and belief, Copeland stated that he would sit in jail for 2 years rather than testify. Upon information and belief, Chief Judge Glanville informed Copeland that Chief Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. So what was going on in this secret meeting was Little Woody was telling the judge and the DA, I don't want to testify. I don't want to be here. I don't want to testify, and I'm going to plead the Fifth. So they said, we'll lock you up. So he said, well, fuck it. I'll sit here for the 2 years till the trial is over, because, you know, they estimate the trial to be over 2 years. They said, nah, bro. No, bro. You're going to sit here until we try everybody. So after these 6, there's like 12, 13 other more cases they got that may go to trial or may not. They're telling him he's gonna sit in jail till they finish with all of them, and knows that it could be longer than 2 years. It could be 4 or 5 years, which is intimidating him to testify, which is clearly illegal. But let's continue to read. Upon information and belief, Judge Glanville informed Copeland that the chief judge could keep sworn witness Copeland incarcerated until additional defendants were tried, not just 6 defendants currently on trial. Upon information and belief, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Upon information and belief, following the above coercion actions by the Chief Judge Glanville in conjunction with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex parte meeting that he would testify. Upon information and belief, Judge Chief Glanville also presented sworn witness Copeland with a printout of perjury statute and false statement statute of the state of Georgia during the ex parte meeting. So the judges carry on more illegal actions. He gave him the printout, like, look, this is the time I can give you. This is what I can give you, which is coercing him to testify. You're forcing him to testify. He, as you can see, he told them, I don't want to testify. I'm going to plead the fifth. And they're forcing him. Upon information and belief, sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. So, as you can see, that in the secret meeting, the DA told him, he told the DA, I'm just going to lie. And they told him, go ahead, you can lie. It's okay. We don't have a problem with you lying. Upon information and belief, sworn witness Copeland also stated to the ADA Hilton that he would testify that he killed Donovan Thomas Jr. Upon information and belief, in response to sworn witness, Copeland stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr. ADA Hilton told Copeland that she would prosecute him for perjury if he testified he killed killed Thomas. So, as we can see, just 2 lines up, he said, Little Woody said, upon information and belief, sworn witness Copeland stated to ADA Hilton that he, if called to testify, he would simply lie on the stand. Upon information and belief, in response to Copeland's statement that he would lie, ADA stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. She would not prosecute. Now, down here, he says he's going to say he killed Donovan Thomas Jr., which is the guy nut, which is there trying to accuse Young Thug of killing. Right? And then, now up here, she says she wouldn't send him to jail or test or prosecute him for lying. But down here, 2 lines later, upon information and belief in response to sworn witness, Copeland stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr. ADA Hilton told Copeland she would prosecute him for perjury if he testified he killed Thomas. Now, so as you can see, he can lie about everything else he want to, but he can't lie about killing Nut. Why? Because they're accusing Young Thug of killing Nut. So he can't lie about that. They don't want him. Oh, you can lie about anything and we won't send you to jail. But if you say you killed Nut, which how she know he didn't kill Nut? Because I don't think nobody's been charged with it. They're trying to charge Young Thug with it. Upon information and belief in response to sworn witness, Copeland stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr. Hilton told Copeland she would prosecute him for perjury if he testified to kill Thomas. During court on the afternoon of June 10th, 2024, when one or more of the above allegations were presented to the court by Attorney Steele, Judge Glanville denied that one or more events above relayed to him were accurate. Judge must cease to act and must make an immediate determination. When the judge is presented with the recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proof would warrant, the assigned judge recusal from the case. Moonday versus Magnolia Advanced Materials, Inc. That's just the law to support what was just said. The present motion for recusal is being timely submitted to the court. The present motion is being filed and presented to the court in a timely manner. Uniform Superior Court Rule 25 governs motions for recusals. Motion to recuse, along with accompanying affidavits, are required to be submitted in the presiding judge no later than 5 days after the affirmant learns of the alleged grounds of disqualification. Such submission shall be submitted not later than 10 days prior to the hearing or trial, which is the subject of recusal, unless good cause is shown for failure to meet the time requirements. Given the most recent incident, the demanding recusal just occurred on June 10th, 2024, a 2-day period elapsing from the incident requiring recusal to the file of present motion is good cause. The present motion includes a sufficient affidavit demonstrating the need for recusal. An accompanying affidavit by Douglas Weinstein, which evidence for recusal has been filed and is now present, which fully asserts facts upon which this motion is founded as required by USCR 25-1. A review of the Weinstein affidavit shows that it clearly states facts and reasons for the belief that bias or prejudice exists, as is required by USCR 25.2. The Weinstein affidavit is specific with respect to time, place, persons, and circumstances which demonstrate bias in favor of the state that prevents impartiality in the present case as required. The particulars of the Weinstein affidavit are provided above and need to be presented again here in detail by lays out alleged acts of Chief Judge Glanville in conjunction with the state with respect to sworn witness Copeland that took place in the chambers of Chief Judge Glanville on June 10th. Recusal is warranted based on facts alleged in the Weinstein affidavit. The facts alleged in the Weinstein affidavit must be assumed to be true when deciding whether recusal will be warranted. The details learned by Weinstein upon information and belief detail the holding of an improper ex parte meeting conducted with sworn witness Copeland, which violated the constitutional and statutory rights of Kendrick, including the right to due process and fair trial. The ex parte hearing with sworn witness Copeland was in violation of at least two sections 2.9 of the Georgia Code of Judicial Conduct. And these are the law. Uniform Superior Court Rule 4.1, generally ex parte communities, except generally permits ex parte communication except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a impeding or impeding procedure. Ex parte hearings are only authorized in the case of extraordinary matters such as temporary restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing, which an opportunity of attending and voicing any objections that may be properly registered. City of Pendergrass versus Skeleton. Now that's the law right there. That's the law. And if you've been watching this trial or if you heard me read this paperwork, we know Judge Glanville broke that law. We know that. And that's just the law, but we don't gotta read the law because we know Judge Glanville broke the law. So, Code of Judicial Conduct, which assures every person, including persons such as Mr. Kendrick, of a fair hearing. Ex parte communications are presumed to have been in error. Rule 2 2.11 in the revised Georgia Code of Judicial Conduct says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one. Moonday at 7:05. The facts must be considered from the perspective of a reasonable person rather than from the perspective of an interested party of the lawyer advocates, or from the subject perspectives of the judge whose continuous presence in the case is at issue. So what that is saying right there is, you can't look at this with judge eyes. You can't look at this with a prosecutor eyes. You can't look at this with a lawyer's eyes. You have to look at this. The facts must be considered from the perspective of a reasonable person rather than from the perception of interesting parties or the lawyer's advocates, or from the subjective perspective of the judge. So everybody in that courtroom don't have a right to have vision on this, because you are an interesting part. You are an invested party. You have an investment in this case. So the judge, once again, he violated the second rule. Furthermore, Chief Judge Glanville should not have coerced sworn witness Copeland to testify. A judge should not attempt to intimidate a witness to testify in behalf of the state, either in or out of the presence of the jury. And that's the law that is under. And we know Judge Glanville did this because we read early on that he told him that I will lock you up for the remainder of this trial. He thought, little Woody thought it was 2 years. He said, no, there's 12 more defendants. That could be 3-4 more years, so you can be locked up for 5 years. That was coercing that man to testify, because of course that man don't want to be locked up for the next 4 to 5 years because he ain't testify. And that's messed up. But we know that Judge Glanville already violated 3 laws. We need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior can indicate that he or she has a personal bias or a prejudice concerning a party or party's lawyer. Defendants were not provided notice of the hearing either before, during, or after, and regardless, defendants should have been afforded the opportunity to attend any hearing where a sworn witness in a critical stage of trial is being coerced to testify. The only logical conclusion to be drawn by the willful exclusion of all defense counsel from the meeting among Chief Judge Glanville, the state, and sworn witness Copeland was to harass and intimidate the sworn witness and to testify. Given that the facts as alleged must be assumed to be true, the Weinstein affidavit is sufficient and that the recusal would be authorized under the alleged facts. Another judge should be assigned to hear this motion to recuse. Whether for Mr. Kendrick respectfully submits that the present motion meets all requirements and this motion should be assigned to another judge for consideration. An alternative, should this court deny the request relief in this motion to recuse, Mr. Kendrick requests that the court must specify factual findings and submits that Chief Judge Glanville should voluntarily recuse himself. Should the court take neither of the above actions, Mr. Kendrick moves that this court for a mistrial due to the ongoing bias of the court as evidenced in the Weinstein affidavit on the bias that Mr. Kendrick is not receiving a fair trial as a constitutional right of due process under the Sixth Amendment. Should all of the above request relief to be denied, Mr. Kendrick requests a certificate of immediate review. Now, they give you the definition of a critical stage of the trial. A critical stage is one in which a defendant's rights may be lost. The defense waived privileges claimed or waived, or one or one in which the outcome of the case is substantially affected in some other way. During the course of the trial, there appears to be eternal inconsistency between Rule 25.1, which mandates that a motion for recusal shall not delay the trial, to Rule 25.3, which mandates that the judge temporarily cease to act upon the merits of the matter. Mr. Kendrick submits that the court can reconcile the intent of these rules by briefly hearing the motion to determine the timeless and sufficiency of the Weinstein affidavit and make the necessary determination without delaying the trial. The court regularly hears motions during the course of the present trial, and this motion is no different. So what that means is, because the judge was like, yo, I ain't stopping the trial for this. Well, Rule 25-3 says, yeah, you supposed to. So, Young Thug, whatever the end of this trial will be, he will get this case overturned, but the question is, how much time will he do waiting to overturn the case? He will do all the time, basically, that they want, because that's what happened when you overturn cases. Those just come 5-10 years later. And basically, that's the end of it. You know, and this is just more of the same paperwork, certificate of service. And this is his affidavit. Basically, it's all what he already said, but for the purpose of the video, I will read it again. Motion to recuse Chief Judge Glanville. Personally appeared before the undecided officer duly authorized to administer oath, Douglas S. Weinstein, which upon being duly sworn, deposed and states the following under oath and penalty of perjury. Sworn witness Kenneth Copeland had been held in civil contempt of court on June 7, 2024 for refusing to testify on that date after being given a grant of immunity by Chief Judge Glanville, who was presiding over the present case. Chief Judge Glanville instructed the witness and all parties of June 7, 2024 that Copeland would be jailed and returned to court on June 20, 2024 at 8:30 a.m., where he would announce whether he was prepared to testify. Upon information and belief, defense counsel were all present in the courthouse at 8:30 a.m. on June 10th, 2024. Defense counsel were all present in courtroom 1C by 9 a.m. on June 10th. Upon information and belief, an ex parte meeting was held in Chief Glanville's chambers on June 10th. Among Chief Judge Glanville, ADA Love, ADL Hill, and other members of the Fulton County District Attorney's Office deputies were warned witness Kenneth Copeland and Copeland's attorney. No member of the defense counsel for any of the defendants in the present case was present at the ex parte meeting. Upon information and belief, no member of the defense counsel was aware of the ex parte meeting before or while the meeting was taking place. Sometime between 11 and 11 a.m. on June 10th, 2024, Chief Judge Glanville took the bench and announced Copeland was prepared to testify. At that time, Attorney Steele, counsel for Mr. Williams, inquired with the court as to what had occurred prior to Chief Judge Glanville taking the bench and inquired, and his inquiry was not accepted. Remember, if you're new here, click that like, share, subscribe, hit the bell, click all so you can get notifications every time I drop one of these videos. Why not? It only helps the channel grow. It never hurts you. You ever wonder how your favorite channel get millions of followers and millions of views? It's because people click the like, the share, and the subscribe. But as I continue, Copeland briefly testified prior to lunch recess on June 10th, 2024. Upon information and belief at the ex parte meeting the morning of June 10th, 2024, Copeland announced that he would invoke his Fifth Amendment rights and not testify. Upon information and belief at the ex parte meeting the morning of June 10th, Copeland stated that he would sit in jail for 2 years rather than testify. Upon information and belief at the ex parte meeting the morning of June 10th, Judge Glanville informed Copeland that CJ Glanville would keep Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Upon information and belief at the ex parte meeting the morning of June 10th, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Upon information and belief following above corrosion, I can't pronounce that word. Whatever actions by the judge Glanville in conjunction with one or more attorneys from the Fulton County DA's office, Copeland stated at the ex parte meeting that he would testify. Upon information and belief, Chief Judge Glanville also presented Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte. Upon information and belief on the morning of June 10th, Judge Glanville in Judge Glanville chamber, Cleveland stated to the ADA Hilton that if called to testify, he would simply lie on the stand. Upon information and belief, Copeland's statement that he would lie, ADA stated that she would not prosecute Copeland if he were to lie on the stand. Upon information and belief, June 10th, Chief Judge Glanville Chambers, Copeland also stated to ADA that he would state that he killed Donovan Thomas Jr. Upon information and belief on that morning, Chief Judge Glanville Chambers, in response to Copeland stating to ADA Hilton that he would state that he killed Donovan Thomas, ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. But remember, just 2 lines ago, she said she wouldn't prosecute him if he lied. But that one lie he can't lie about. Why? Because they're trying to allege Young Thug killed Nut. During court on the afternoon of June 10, 2024, when one or more of the above allegations was presented to the court, Chief Judge Glanville denied that one or more events above relayed to him were accurate. Further evidence saith not. So, as you can see, this trial is a big shit show. The judge has definitely opened the door for Young Thug many times to get his case overturned or to get a new trial, because the judge is definitely violating all type of laws in this case. So it is what it is. Like I always say, man, click that like, share, subscribe, hit the bell, click all, so you can get notifications every time I do these videos and give you this paperwork or give you my unbiased opinion. It's never gonna hurt you. It's only gonna help the channel grow, and that's what it's all about. Channels grow. I hit like on a video even if I watched 2 seconds of the video and didn't like the beginning of the video. Why? Because I don't have a problem with that channel growing. I know what it takes to do a YouTube channel. It's a lot of work. So why would I sit here and watch for free and not like or not subscribe? Even if I never go back. I got a lot of subscriptions that I never even go back and watch a video again. But I'm subscribed. I'm dedicated to help people get bigger. But like I always say, if you're a supporter of the channel, much love and respect goes out to you. And if you're one of them haters, cut the shit.